Good evening, members of the gallery, officers and councillors. Welcome to the first Ordinary Council meeting for 2024. It's my humble duty to declare this meeting open Monday the 19th of February 2024 at 7 p.m. I acknowledge the Noongar people, the Wodja, the land that we gather on today. For thousands of years, their connection to country has provided knowledge, guidance, spirituality and life. We pay our respects to their ongoing connection, as well as to their elders, past, present and emerging. I will advise all members of the gallery that tonight's meeting will be audio recorded in accordance with our own council policy. If you're asking a public question or making a statement or deputation to the meeting, this will be audio recorded. Members of the public are reminded that no other visual or audio recording of this meeting may be made by any means. Item 1 on tonight's agenda is attendance and apologies. We do have one apology, and that is Councillor Nathan Bishop. Agenda item number 2 on tonight's agenda is public question time. 2.1 is response to previous public questions taken on notice. I won't read those out, but they are in the agenda that will be published. Agenda item 2.2, public questions, and public question time will commence at 7:01 p.m. The first question I have received is from Mr. John McEwen. I'd ask Mr. John McEwen to come forward.
Thank you, Mr. Speaker. My first question is, in relation to dust and dust management, the responsible authority referenced precast grinding, finishing of bridge beams, precast form cleaning using pneumatic chipping equipment or compressed air blown guns, dry sweeping and compressed air use in concrete manufacturing area, cutting, drilling, surface finishing of concrete products with chisels, hammers, chippers, etc. Where is this work being done? Why is this work not discussed by the applicant in retrospective approval application? And how is this going to be controlled and monitored?
Mr. McEwen, thank you for your question. I'll ask the Director of Development Services to provide an answer.
Thank you, Mr. President. Through you. The mentioned points above are not specifically addressed in the draft dust management plan, as they are not identified as likely contributors to dust. However, to ensure completeness, the officer report does identify the need for minor modifications to the draft dust management plan to depict the management practices in place for these activities. Thank you.
Thank you, Director. Mr. McEwen, would you like to ask your second question?
Question number 2. 394 Robertson Road is occupied by Permapol, Permacast and WA Premix, the concrete batching plant. Permapol and WA Premix are prescribed operations. For an as yet to be determined reason, Permacast is no longer a prescribed operation. The company's shared premises, entrance/exit driveways, concrete produced at the batching plant is delivered to Permacast stressing beds. Neither Permacast nor WA Premix have bore licenses. They use the Permapol bore water. Permacast excess stormwater can now be dumped, eventually flowing onto residential land. Can you please explain how the stormwater from the prescribed areas, which is the Permapol and WA Premix, are being prevented from mixing with the non-prescribed areas?
Thank you for your second question, Mr. McEwen. Again, I'll ask the Director of Development Services to provide a response.
Thank you, Mr. President, and thank you for the question. According to the draft stormwater management plan, the Permacast site is separated into 5 drainage catchments. The northernmost catchment, which is catchment number 5, is limited to the existing driveway only, which has recently been sealed. This northern catchment drains to the northern basin located on the permapole site and is the limit of any water flowing north. This catchment therefore has no stormwater entering it from any other locations on the permacast site. The stormwater emanating from all other parts of the permacast site are captured and directed to the southwestern drainage basins. According to the draft stormwater management plan, this depicts that the sites do not mix their stormwater.
Thank you, Director. Mr. McEwen, I'll ask you to please ask question number 3.
Laydown area was approved by the Shire on the 9th of June 2023. One of the conditions was that no stormwater must leave the property and the area had to be sealed. The laydown area covers an area of 21.3 hectares, of which, to our knowledge, most has been sealed. Has the agreed containment basin been built to hold all the stormwater from lot 21, or is the stormwater to flow through the prescribed WA premix and the non-prescribed permacast, or is it to be diverted through the prescribed permapole site to be eventually dumped onto private land?
Thank you, Mr. McEwen, for your third question. Again, I'd ask the Director of Development Services to provide a response.
Thank you, Mr. President, and through you. As per the condition, the applicant has submitted a stormwater management plan for lot 21, which has been approved by the Shire. Drainage works according to this plan are in the process of being completed, which includes a northwestern basin and series of swales, which link the 3 catchment areas of the hard stand on lot 21 to that basin. And stormwater must be managed as per the condition and the approved plan.
Thank you, Director.
And I'll just follow up on that. So you're telling me that all water is going to be contained on lot 21. That dam's going to be big enough.
Mr. McEwen, you have submitted your 3 questions. I'm happy. What I will do is open up after the end of the submitted questions for you to then come forward and ask questions that notice hasn't been given. Thank you. I would ask now Karen McEwen comes forward to ask her question.
In the Responsible Authority report in relation to stormwater, it states catchment 4 and 5, area 2.0626 hectares and 0.51 hectares respectively, consists of roads, hardstand areas and buildings. The surface runoff from catchment 4 is conveyed to a proposed basin by swales and culverts. The surface runoff from catchment 5 is collected in a swale and culvert network that conveys flows to the existing permapole dam in the northwest corner of the site. Permapole is a prescribed premise. Permapole dam contains dissolved copper, chromium, and arsenic. These contaminants are meant to be monitored before any water from the dam is emptied. Due to the lay of the land, catchment from catchment 5 would have to be pumped up to the permapole basin. Has a pumping facility been installed for this to take place? Has a study been conducted to determine the effect of the catchment 5 water on the solubility of the copper, chromium, and arsenic contained in the permapole dam?
Thank you for your question, Ms. McEwen. I would ask the Director of Development Services to provide a response.
Thank you, Mr. President, and through you. Should approval be granted by the Development Assessment Panel, stormwater would be required to be managed in accordance with the approved stormwater management plan, including any infrastructure needed to implement that plan. The Department of Water and Environment Regulation license and regulate the permapole site as a prescribed premise, and that's category 29, timber preserving. In terms of the study you mentioned, they would be the appropriate agency to determine if a study of this nature was required as part of their ongoing licensing and regulation of the permapole site.
Thank you, Director. Ms McEwen, would you like to ask your second question?
Yes. My second question is, the application does not specifically state Thermocast operating hours. The internet states operating hours of 8:30 a.m. to 5 p.m. Monday to Friday of this concrete factory in Cardup, Western Australia. What are their actual permitted operating hours?
Thank you for the question, Ms McEwen. Again, I'd ask the Director of Development Service to provide a response.
Thank you for the question through you, Mr. President. There are no specified operating hours for the development currently, as this application is seeking retrospective development approval. The application does, however, propose hours of operation of 7 a.m. to 6 p.m. Monday to Friday. Thank you.
Thank you, Director. I'd ask Ms Lisa Brazier to come forward and ask her question.
Good evening, councillors. My questions are related to tonight's item 9.2, notice of motion with the telecommunication towers. I'm on record for being very vocal on the absolute debacle of delivery of this service and councillors' involvement, and I too want to see this tower active. However, does council think that writing to the Federal Minister is the most appropriate way forward, given that the mover of this motion was in actual fact the same councillor that voted against the officer's original recommendation, then brought a revocation motion back to council to have the tower placed back in its original position, thus disrupting the telecommunication company's work schedule? Are we not better to deal directly with the telecommunications company rather than potentially portraying ourselves as a shire who cannot function professionally and risk our future relationship with businesses? The Shire councillors disrupted the work schedule, and now you want the Federal Minister to come over the top of the telecommunications company. Have we exhausted all efforts to work collaboratively with the telecommunications company involved before we take such action?
Thank you for the question. I would ask the Director of Development Services to provide a response.
Thank you, Mr. President, and thank you for the question. Officers have previously contacted the telecommunications company, who have advised, as per the officer comment, that the infrastructure is expected to be completed in the second half of 2024. Officers were advised in that correspondence of construction delays, including some issues with the power supply. Council, in its consideration of the matter, could ask that officers advocate with the telecommunications company also. Thank you.
Thank you, Director. Ms Brazier would like to ask your second question.
Telecommunications is the responsibility of the federal government, and I have lobbied our local federal member since 2015 for increased communication towers within the Shire and in particularly in Mundajong. Given that we are heading to a federal election in 2025 and the political field is hotting up, has the Shire considered all possibilities and implications by involving politicians in this issue rather than working directly with the telecommunications company? Given that a Liberal member of Parliament secured the Whitby poll and that you are writing to a Labor member to intervene in the completion of this service, for which the Liberal member will be able to take credit in delivering the service once complete. You see there's a problem there?
Thank you for the question, Ms Brazier. I'll answer that, and council can consider this issue tonight when the notice of motion is considered. Thank you for your question. Public gallery, I'll now open the floor to anyone who'd like to come forward and ask a question without any notice. Mrs Bond.
Why is it predicted to take possibly 2 years to establish how much contamination is on the Watkins Road transfer station site and whether it can be cleaned up? What has been the total cost since the contamination surfaced? What is the total cost for the contract? Does it include the cleanup? If not, is another amount required for the cleanup? If yes, what is the total cost? Who is doing the assessment of the contamination and who authorised the opening of this site to be used as a waste station? Date and the reason it was originally closed as a tip in the first place and the date.
Mrs. Bond, thank you for the question. I will take that question on notice, and the Director of Infrastructure will provide a response. But what I would say, and I've been quite clear on this, and I've been on the record since I became the President in October, the thing that's most important for me is the safety of our residents and ratepayers. I will not be part of a Shire or the Shire President opens a facility where we're not unequivocal that there is no asbestos there and the safety of our residents and ratepayers cannot be guaranteed. But the rest of the answer will be provided in writing on notice by the Director of Infrastructure.
On the side of that,
Do you have another question, Mrs. Bond?
yep. Please provide dates, times, temperatures, what animals were incarcerated at the time, and what officer of the Shire attended the animal incarceration site on Watkins Road, Mundijong, from the date you claim to have performed the above at the site, and does the Shire still have the agreement with Armidale Council to move incarcerated animals within an hour of them being impounded? Has any councillor made any serious attempt, evidence-based, to bring this matter to council since 2015? To have this site either closed down or built to a standard of nothing less than what is required by law for the safety of all animals?
I thank you for the question, Mrs. Bond. It is an item that's going to be considered tonight on the agenda. I don't know whether the Director of Infrastructure Services would like to provide any answer now, whether we take it on notice. Thank you for the question, Mrs. Bond. Do you have a third question?
Why are some councillors permitted to constantly drone on when debating an item on the agenda when much of it is a repeat over and over again? Can we limit this to no more than 3 minutes per councillor per item?
I can answer that question, Mrs. Bond. It's in accordance with our standing orders. If any person believes that we talk for too long, we can bring the standing orders back to a policy concept forum and we look at amending it. But certainly the debate since I've been the presiding member has been in accordance with the standing orders.
Does that include us in the gallery if we don't like getting bored?
I'll take that as a rhetorical question. Thank you, Mrs. Bond. Are there any other questions from the floor? If there's no further questions from the floor, I declare, Mrs. Rich, I'd ask you to remove your sunglasses from your head too, please, as you come forward. Thank you.
Good evening, councillors.
Could you please remove your glasses from your head?
My one question I have this evening is, could I please ask that the CEO publish in the minutes of this meeting the number of farmland concession property owners that have seen this item come to council, whether they put their applications to have this heard by council in writing, and the localities of the Shire of where those property owners are from. Thank you.
Thank you for the question, Mrs. Rich. I do notice that you have not removed your sunglasses, and I did ask you to do that. What I would say is that the questions need to be...
I do remember very prominently you standing up at an electors meeting and telling me I had no right to be a Shire President because I did not dress appropriately and I wore my sunglasses on my head. Thank you.
Just for the record, there is no person known as Councillor Coles. If you would like to address me as President Coles, thank you. Are there any other questions from the floor? Thank you. That being the case, I declare public questions closed at 7:19 p.m. Agenda item number 3 is public statement time. The first statement that we have received is from Mr. John McEwen. I would ask Mr. John McEwen to come forward and make his statement. Thank you.
Thank you, Mr. President and councillors. My statement is regarding the proposed retrospective and prospective approval of Lot 60, 394 Robertson Road, Cardiff. I oppose this retrospective approval and request that council recommend that the Metro Outer Joint Development Panel refuse DAP application reference DAP/23/02462. We have been studying the history of this site, and the more I find out, the more shocked I am. How is this company still operating at this site despite all the evidence and complaints from residents, despite illegally building an entire heavy industrial plant, despite tearing down a large part of the bush forever that they vowed to protect? Permacar's claim that we are spreading hysteria because we are concerned that the contaminants in concrete and cement will affect the health of residents and children at the school nearby. Concrete and cement premises are prescribed for this very, very reason. Throughout history, polluting companies have made similar claims and demonized the victims. And like this company, have been supported for the government for years by the government. For instance, although the first recorded diagnosis of asbestos in Australia was made in 1933, it only started being regulated in the late 1970s, and its use was finally banned as recently as 2003. There are plenty of other examples, such as the tobacco industry, vaping industries, and the reconstituted stone and granite industries. So here in Cardiff, do we have to wait 10, 20 or 30 years for an unusually high level of incidence of cancer, infertility or birth defects in the local residents and children that attend Court Grammar School for the government to begin to take action? Inaction is complicity. In the PN notice that was issued on the 9th of August, 2023, the DWER attempted to protect us from just these issues. For instance, the drainage basin was required to be lined and to hold leachant and stormwater as a result of the 1 in 100 year storm event. The basin needed to be certified by a qualified engineer. However, once the DWER decided that this was no longer prescribed premise, all these protections were downgraded and we are no longer afforded these protections. The EPN that was issued on the 17th of October, 2023, no longer required the basin to be lined or certified. All Permacast was required to do was put in place silt and sediment traps. And furthermore, they're able to release water from the premises. The traps do not prevent dissolved contaminants from passing or entering groundwater. In their original retrospective approval application, Permacast claimed that their water basin is 16,500 cubic meters. 16,500 cubic meters. We queried that, and now they claim it to be 10,800 cubic meters. We doubt that it can even hold as much as this, because it would then have to at least be 3.5 meters in depth. It is more likely that it holds around 1.5 meter of water. However, they no longer have to have the dam certified. The dam sizing is just one inaccuracy provided by Permacast. The entire application, as well as the applicant's comments, is full of inaccuracies and inconsistencies. For instance, they claim the concrete batching plant has approval to produce 280,000 tons per annum of concrete. It does not. It has approval to produce 146,640 per annum. Furthermore, they swear they do not manufacture concrete, whilst continuously referring themselves as the proposed concrete manufacturing facility. They continuously understate their emissions and obligations, such as in the noise report, dust management report, and the bushfire report, etc. From 2006, they have tried to get control of the Bush Forever area while vying to revegetate and protect it. They've done not, they have done neither. They have been eroding and denigrating this area while absorbing it into their plant. In their own words, the bush forever is under their control. No doubt they will continue to deplete it. Permacast has continued to expand with little disregard for the planning framework, rules and regulations. We are unable to understand the reason for permacast being downgraded from a prescribed to a non-prescribed premise. DWER officers advised us verbally that it was due to the wording error in the legislation that would be fixed at a later date. The legislation is actually very, very clear. Prescribed is applied where concrete batching or cement product manufacturing is over 100 tons per year, and where cement product manufacturing means the manufacturing of products in which cement or concrete is the principal ingredient. The documentation relating to this decision has been denied us, despite paying the requested freedom of information fee. We are currently awaiting the outcome for an external investigation regarding the access to this document. The officer comments in relation to endorsements for permacast by employees and contractors is, it is acknowledged that the proposed concrete manufacturing facility creates employment and contributes to the economy of the local community. This is not a reason to condone this facility. Instead of illegally building their plant in an inappropriate area, they could have legally established themselves at a site that was large enough and suitable for this type of operation, such as the West Mundijong site that is already approved for heavy industry. Only 4 kilometers away. Only 4 kilometers away could they have established this. Create an environment that is toxic and inharmonious does not in any way contribute to the community. Drug dealers create employment. That does not mean we want them in our community. On Saturday, the 15th of July, 2023, my wife and I were woken up at around 5:30 by a huge amount of noise from the facility, including a metal grating noise. We tried to sleep but could not. We eventually decided to go for a walk with our dog, and on the way home, we decided to complain to the permacast facility personally. We started walking up the drive and we were met by Mr. Antonio Ferreira in his ute. He responded with this. This is an industrial site to our complaints. When we complained that the operation was not approved, he told us that it had been and he had seen all the approvals. We found out recently that at some point in time, he photographed us. He photographed us complaining and presented the photograph to the DWER as evidence of us trespassing. Permacast is supposed to keep our complaints and act on them. I do not trust them and will not have any further dealings with them. In August 2023, the MODAP granted Permacast 30 days to mitigate the numerous issues raised. The additional information provided by Permacast is full of inaccuracies and inconsistencies. The information they have provided does not demonstrate that their emissions and impacts can be managed within the boundaries of the site. Permacast have been condoned and enabled despite building an operation illegally and accepting no responsibility for their negligent behavior towards the community and the environment. Inaction is complicity. Remember, inaction is complicity. Please vote to request MODAP to refuse this application. Thank you.
Thank you, Mr. McEwen. I would ask Ms. Lisa Brazier to come forward and make her statement.
Good evening, councillors. My statement tonight refers to the debate that occurred at the OCM on the 11th of December 2023. Item 9.2, Notice of Motion, Improving Council Transparency and Accountability. During the debate of this item, it was argued that the Shire is like a company and referenced the similarities to the board directors with councillors, shareholders and residents. Similarity to shareholders and residents was referred to on 2 occasions during the debate. It concerns me greatly that councillors around the table did not call a point of order, as there was a very clear breach of code of conduct under clause 10, council or committee meetings, section B, which when attending a council or committee meeting, a council member, committee member or candidate must not make a statement that the member or candidate knows or could be reasonably expected to know is false or misleading. Given that no councillors acted on this debate, I'm assuming none of you understand the falsity of the statement that was made during the debate. Company is a legal entity that can be formed by one or more individuals to operate a business. In Australia, there are 2 types of companies, public and private, whereas LGAs, local government authorities, are formed by the state government. Companies are managed by directors, and within LGAs, councillors form a similar role, where both oversee the governance of the entities, but not the operations. During the debate, and I quote, "We have shareholders as our residents." It is this statement that is false and misleading. A shareholder is a person who has ownership in the company by owning company stock and has certain rights and responsibilities. Some companies pay dividends to their shareholders, where an LGA resident is someone who lives within the LGA boundaries. There may be a landowner who pays taxes to the LGA in the form of rates as defined by the Department of Local Government, Sport and Cultural Industries. They may not own land and may pay rent to the landowner, or, as in my case, reside within the LGA, own no property, nor pay rent, thus effectively benefit from everything provided within the LGA for no contribution. So you can imagine when sitting in the gallery at the December OCM how excited I was to learn that I was actually the same as a shareholder of a company. So that to the acting director of finance, we've been profitable in the past few years. So I'm looking forward to next year's budget to include a dividend payment to all residents. Now, I acknowledge that having an accurate register prior to ex-dividend date will be quite a task. However, look at the positives. We will finally have a record of everyone who resides in the Shire. This will no doubt assist the communications team immensely. As to receiving a dividend, my preference would be for those dividends to be fully franked. However, if this is not possible, then 30% would be suitable. In the case of ownership, as we do not have issued shares, I would like to get in early and maybe have some ownership in any of the Shire's profitable assets. So, councillors, I trust you can see the absurdity of the debate in relationship to comparison of shareholders and residents, and that it was false and misleading, as a shareholder has ownership of a company and may receive income, whereas a resident simply resides in the Shire and enjoys the amenities provided by the landowner who pays taxes. The role of the council, as prescribed by the Act, is that it governs local government affairs, is responsible for the performance of local government functions, oversees the allocation of local government finances and resources, and determine local government policies. As councillors, you are bound by the Shire of Serpentine Jarrahdale Code of Conduct, which applies to your debate. If you are unfamiliar with this code of conduct, please review it, because false and misleading debate needs to cease at this council table. It is sloppy and lazy. You do not know your subject matter, then either do not use it or do the research to understand what you're stating in debate. Thank you.
Thank you, Ms. Brazier. Are there any members of the gallery who'd like to come forward and make a statement? Thank you, Ms. Berry.
Thank you. Ms. Brazier raised an interesting statement there. In 2018, this Shire paid for some training for Councillor Coles, instituted a company directors course. And interesting
Ms.
enough,
Berry,
had he actually
Ms. Berry,
completed that course
Ms.
and
Berry,
attended it, he would have
Can we
actually
turn
pulled
that
that up
microphone off, please,
during that
Mr.
meeting.
CEO? Can we turn the microphone off, please? The question's been asked several times. It's been answered, Ms. Berry. On the record, I will say you are now bordering on bullying me, and the Shire will not condone members of the public bullying staff or councillors. Are there any other statements from the floor? Thank you. That being the case, statement time is now finished at 7:36. Come on then, Mrs. Bond. Sorry, Madam. Yeah, got it.
What next month? Council meetings are available for people to bring their questions and statements forward in a respectful manner. Coming to meetings to humiliate, denigrate, defame, and just generally show your lousy upbringing is not what the majority of those attending want to be subjected to. Hateful behaviour on a repetitive basis is not something anyone can be proud of. Keep your hate in your own home and allow the rest of us to be spared this disgusting behaviour. 3 months now, we have had a new president, and constantly he has been attacked by those who did nothing while in power, and suddenly he is responsible for all the wrongs. Ask who was involved in the opening of Watkins Road transfer station contaminated site. Ask what they knew about the contamination, and they did know because I did. Ask why they did nothing about the animal incarceration site found. They knew about that for far too many years and ignored it. New president wasn't around, and if he had made any remarks on this, I am sure he would have been howled down, as he was many times over when trying to right wrongs. Stop wasting money on Kiernan Street. Overspends on building a monument to a select few is deplorable. Hand any leftovers back to the state government if it is their funding. It won't be the first time this Shire has had to hand money back to the state government. Make a concerted effort to build a proper animal pound that we can be proud of. Stop wasting money on groups that don't make sure we know where the money is spent. Minutes must be provided for the ratepayer to peruse. If your intentions are to come to meetings to be disruptive, stay at home and let the new president do his job without your disgusting attacks for no reason other than you are full of hate.
Thank you, Ms. Bond. I declare public statement time closed at 7:38 p.m. The next item on the agenda is agenda item number 4, which is petitions and deputations. I'd like to ask Julia Skinner, partner Thompson Gear Lawyers, on behalf of Permacast regarding item 10.1.1, lot 6, 394 Robinson Road, Cardup, to come forward and make his deputation. Thank you.
Thank you, Shire President, councillors, officers, for the opportunity to make this presentation to you. Essentially, we wish to request that Council support option 2 of the officers' report for you today in relation to Permacast, and in particular, I want to explain why it's not appropriate to ask that the matter be deferred again, particularly on noise grounds. For dealing with probably the main issues that are out in the deputations, a couple of things I just wanted to clarify or confirm. The first of them, Permacast has offered on a number of occasions to conduct a full on-site briefing and walk around. That offer has been taken up by a number of the Shire's officers. I'm grateful for that, and that offer remains open in time in respect to councillors who may wish to have a tour of the facility and see what's carried on. Second point is that the works that have occurred on site over the previous 2 years, particularly dressing bed number 4 and supporting infrastructure, meet the definition of public works under the Public Works Act. The dressing bed 4 infrastructure is actually owned by the PTA, and the concrete bridge sections that are produced within it are to support the Metronet Byford rail extension and the Metronet raised rail project. Those things railway works are expressly recognised in very recent amendments to the Public Works Act as public works. Thirdly, and perhaps most importantly, is to clarify that Permacast does not operate a concrete manufacturing facility on the site. The repeated references in the report to concrete manufacturing or concrete production per annum are correct. Permacast does not manufacture concrete. It pours concrete that are made by others into moulds, stressing beds, and once the concrete is set, the bridge sections are removed from the mould, cleaned and stored on the adjacent lot 21 until such time as they're called up to be installed. That takes me to segue into the first point really raised by the deputation to do with the EPA separation guidelines. They're referred to in the report to council, and the recommendation is an application of a 750 metre buffer under that guideline. The most important point to make in relation to that is the buffer referred to in the guideline is in respect of particular prescribed premises called cement product manufacturing. The cement product manufacturing is a specific type of prescribed premises under the Environmental Protection Act. It's defined to include concrete batching plants and premises upon which cement products are produced. The definition that you were led to earlier on comes from a different piece of legislation. It is not the definition of the prescribed premises of cement product manufacturing. The guideline on the 750 metre buffer simply do not apply to Permacast operations because no concrete or cement product manufacturing occurs and the facility is not a prescribed premises. Now, it's not just Permacast saying that. The DWER, which is the regulatory body that ministers and licenses prescribed premises, has agreed that position. The other main point to cover relates to the noise and noise regulations. And again, the starting point is the fact is that DWER, and this is attachment 10 to the report to council signed by the Executive Director of Compliance at DWER, confirms that DWER are satisfied that suitable noise mitigation and emissions controls have been implemented to ensure that noise levels are within the assigned levels and in compliance with the noise regulations. That was based on DWER's own independent assessment using their own equipment during testing that led to the lifting of the prohibition on production. Since the lifting of the prohibition on production in late November, the site has been fully operational. It's been producing beams within stressing bed 4 every 3 to 4 days since then. All production has occurred under CCTV footage and with full-time noise monitoring occurring. All of that data has been provided to DWER, and DWER remains satisfied with compliance with noise regulations and other matters. There's reference in the report to commentary from the ENB branch of the DWER. They've confirmed that reference there. They confirm that it's subject to implementing the mitigation measures. Compliance with the noise regulations may be achieved. We said in the deputation, they've used the word may. That's entirely appropriate, but what they've actually said, listed there under paragraph 14, they've said basically 3 things that are important. One is that the assigned levels apply to the noise emissions from the whole premises, not just stressing bed number 4, which is correct. Testing occurred under the full operation of the site. Testing did not occur when only stressing bed number 4 was operating and the rest of the site was shut down. The second point that's made by the ENB branch is that the noise emissions from SB4 must not be tonal. Again, completely correct, but tonality is a defined term under Regulation 9 of the regulations, and the noise emissions during the testing and since then have shown that the noise does not meet the requirements to be tonal. And that test for tonality determines whether a 5 decibel penalty is to be applied. Again, that's been confirmed by DWER. The noise is not tonal and therefore that 5 decibel penalty does not apply. The third point that's made by DWER and mentioned in the report is that the noise emissions must not cause or significantly contribute to a level of exceedance by receivers. And again, completely correct as a statement. What it's effectively saying, though, is that if the company causes the exceedance, they'll be in breach of the regulation. What's more important, though, is that the testing and monitoring that's put in place has repeatedly and consistently demonstrated compliance with the regulations, not exceedance. There's also reference to commentary or reference in the report to commentary from the Shire's noise consultant. gone through some of the issues that are raised in relation to that in the deputation. In essence, though, the assertion, well, it's not really an assertion, but a suggestion in the report that there is non-compliance with the noise regulations by up to 7 decibels is disputed. It's even set out in the report, but it's based on a number of assumptions itself. It's been based on the application of essentially a 12 decibel increase to the noise from what it actually has been measured at by DWER. The consultant's suggestion that the noise was measured in isolation is simply incorrect. As I've already said, DWER did not do that. They tested the measurements were undertaken when the full site was in operation and has been ever since. The issue around the influencing factor, with all due respect to the Shire's noise consultants, the maps that are shown in the report simply incorrectly address the issue of the influencing factor under the regulations. It's been correctly carried out by DWER, and more importantly by Permaculture. The other point raised, the Shire's consultant flagged that if tonality is detected, then a further 5 decibel penalty is to apply. Now, the comments in there then apply that 5 decibel penalty, but the problem is it is only of need to be applied if the tonality is detected. And as I said, it hasn't been detected and it doesn't meet the requirements for tonality. So that 5 decibels simply doesn't apply. Shire's consultants also flagged if Permacast's operations significantly contribute to the level of noise measured at the closest receptor, then a further 5 decibel penalty effectively applies. But again, the statement is correct, but the fact is that Permacast's operations have been found not to significantly contribute to the level of noise calculated under the noise regulations. So that penalty simply doesn't apply. And we've expanded upon that with a couple of particular examples in the deputation. The important point being from there that the ambient noise measured by the Shire's own consultant at the closest house over a 10-minute period was 76 decibels, over a 90-minute period was 49 decibels, and the minimum recording at any time during the period of the assessment was 46 decibels. The noise that's been generated by Permacast's operations as measured and clarified and confirmed by DWER was 44 decibels. It's less than the quietest ambient noise that was measured by the Shire's consultant. And finally, reference in the deputation point that's made in the report, which is entirely correct, that noise and noise regulations are not the be-all and end-all, or the noise regulations are not the be-all and end-all in terms of noise as a planning issue. That is a matter that the State Administrative Tribunal has ruled on a number of occasions, and some quite recent decisions. I've gone through it again to explain that compliance with the noise regulations is essentially a starting point. It's not the end point, but the end point has to be a consideration of whether the noise is reasonable or is going to cause undue offence and annoyance. That is where you have to start then with what is the noise currently being experienced in the locality and what are the circumstances of the locality in order to assess whether or not the noise is unreasonable. But typically, this has arisen in the tribunal in particularly quiet localities where compliance with the noise regulations would still amount to unreasonable noise. I've involved in a number of cases where that's been the focus of the evidence of the tribunal. And there have been cases where the tribunal has found that even where noise doesn't exceed requirements, is nevertheless found to be incompatible with the locality. But there are circumstances where the locality itself is already exceeding, or starts off being exceedingly compliant. This is not the case we're dealing with here. Closest sensitive receptors sit opposite a zoned industrial area. They're on a district road that generates hundreds of vehicles every hour, opposite a regional railway line, in close proximity to a regional freight railway line. And within this context, the LA10 level of noise is 48 decibels, and the recorded level confirmed by DWER of Permacast noise is 44. It's significantly less than the ambient noise. Just to put that into perspective for the purposes of councillors, at 45 decibels, out the sound of light rain. My speaking to you now is well in excess of 45 decibels. The question you need to ask yourself essentially in relation to the planning issue, whether a noise that is essentially equivalent to, say, 45 decibels is around the noise generated by a domestic refrigerator. The question is whether that, during daylight hours, Monday to Saturday, an area opposite a district road, regional railway and a zoned industrial area is unreasonable, unwarranted or offensive. Have with us today representatives of Permacast if there are any questions, otherwise good night.
Thank you for your deputation. I will remind all members of the public to please ensure their mobile phones are turned off or at least on silent.
President, can I please ask a question of Mr. Skinner?
Certainly.
Thanks, Mr. Skinner, for your deputation this evening. I found it quite intriguing, especially when you discuss the noise regulations of not being the be-all and the end-all, and that it's more important to look at if it offers undue offence or annoyance to the residents. And it made me wonder, have you actually stood on Soldiers Road when the Permacast has been working?
Me personally, no, but members of my
No.
office have during the course
I
of
can
this.
tell you I have. I can tell you I have. Thanks.
Excellent.
Sorry, I will ask a question. Obviously, the people in high vis are workers of Permacast. Is that, or a subsidiary of Permacast? Is that
I believe that's the
is
case.
that correct? How many of those reside within the Shire of Serpentine Jarrahdale?
People who reside and
Thank you. Normally, people are proud to put their hand up and say they live in the Shire. Thank you for your deputation. I'll now move to Karen McEwen and John McEwen. I'd ask you to come forward and make your deputation. Is it going to be missed? Yeah, thank you.
Thank you, Mr. President. As you know, we are here in opposition to the proposed retrospective and prospective approvals at 60 Robertson Road. This item came before the Shire on 21st of August 2023. At that meeting, the responsible authority recommended that the council refuse that application DAT/23/02462. At the MODAT meeting, the decision to defer the approval giving Permacast 30 days to update its plans and provide information regarding its emission control and other items. Since its previous application, the Permacast has installed even more structures and more parking bays. However, Permacast has not been able to provide any information to show that they are able to control their emissions. They are still on a site that is too small and too close to sensitive residents. Only change is that the bar has been lowered and the premise is no longer deemed prescribed. We are trying to get access to the related documentation. To date, we have been unsuccessful. The case is currently with an independent assessor. We have requested DERWA to provide a map of the premises, showing which areas are prescribed and which are not. We are still waiting for this information. This is bound to be complicated given the areas such as roads and water basins are shared. How this facility is not a prescribed premise is beyond our understanding. The legislation is actually very clear. Schedule 1 of EPA regulations in 1987, category 77, assigns concrete batching or cement products manufacturing premises on which cement products or concrete are manufactured for use at places or premises other than those premises, where more than 100 tons per year are produced. Permacast is capable of producing 300 tons per day and is to produce 72,800 tons per year. Furthermore, the Environmental Protection, Concrete Batching and Cement Product Manufacturing Regulations 1998 contains the following definition. Cement product manufacturing means the manufacturing of products in which cement or concrete is the principal ingredient. Concrete means a mixture of cement, sand, aggregate, and water. The reason that prescribed premises are assigned to cement and concrete product manufacturing facilities is because they contain carcinogens and low-level radioactive materials. Our concerns that these poisons are being allowed to enter the groundwater has been ignored. Sediment traps will not stop dissolved poisons and hydrocarbon runoff from entering the groundwater. Please refer to the MSDS documents for Portland cement, the main component of concrete, and the references regarding the dangers of concrete and cement in our submission. What is happening in relation to this site is a travesty of justice. Any of you that actually has a conscience and has some small regard for legal responsibilities should again vote to recommend that MODAP refuse this application. Noise. Permacast built a high-tech noise wall consisting of a bunch of sea containers stacked and partially painted. As attractive as it is, it makes no difference to the noise. Just using the raw data submitted by Permacast from stressing bed 4, they reported LA10 of 48 to 50 decibels in their results reported at the 21st August 23 Shire meeting. This was before the containers. In their current report, they measured an LA10 of 46 to 52 decibels during the initial testing. This was after the container. Although the stressing bed 4 machinery was adjusted to optimize the noise levels, the noise level is still too loud as calculated by peer reviewers, and more importantly, as heard in my bedroom. Stressing bed 1 was noisiest as reported in Permacast's original report. However, only stressing bed 4 was assessed in the current report. None of the other banging, crashing, hammering alarms and screeching noises were considered. Dover removed the EPN on 28 November 2023, citing that the results of the second test conducted on 15 November 2023 achieved compliance with assigned noise levels in noise regulation. However, in Dover's submission comments, this is not the case. What's going on? Submissions. There are so many issues with this application, but I only have 5 minutes. Please read the submissions as they voice our concerns and raise many issues with many concerns reported over and over and over again. Please be wary of the applicant's comments, as many are outright lies or simply incorrect. Many people cited their concerns regarding the decrease in property prices in Carter. Officer comment to this is, impact on property prices is not a planning consideration. Well, it should be. If the purpose of planning is to ensure a secure, prosperous suburb. On 14 February, REVA reported a drop in the median sale price of houses in Carter from $1 million to $860,000, a 14% decrease. This is despite an increase in prices in most other suburbs in Western Australia, including Byford. The agenda cites 38 submissions in favour of Permacast application. These submissions are from Permacast employees, Vesta Enterprises Pty Limited, Henderley Pty Limited, and Mecca Holdings, the landowners, that no doubt have significant financial gain from this development. Some of the employees are so enamored by Permacast that they drive 40 minutes to work. One of the reasons this land was zoned industrial was to stimulate employment in the area. I'm curious as to the percentage of employees that actually live in the area. 20 kilometers away is actually Kwinana. MRS Amendment 1215 on 41. The zoning of the land from rural to industrial was based on the economic and employment land strategy, non-heavy industrial, and draft outer metropolitan Perth and Peel sub-regional strategy. The rezoning was to support non-heavy industry and employment in the local area. This site was never intended for heavy industry. At the time, the EPA noted that the proposed rezoning will result in existing residences having non-conforming use rights. The proposed amendment will allow a number of land uses which are incompatible with residential dwellings. Proposed industrial land uses will need to be separated from existing dwellings with an adequate buffer as described in the EPA's guidance statement number 3, separation distances between industrial and sensitive land uses. This does not apply to only prescribed premises. Permacast illegally built a huge heavy industry plant without any consideration for the EPA's guidance documents. Projects. Although it is to date an illegal operation, Permacast has been awarded several government contracts, including the Byford Rail Extension and Armadale Line level crossing removal. In 2020, Infrastructure Australia assessed both projects and concluded that the costs are greater than quantified social, economic, and environmental benefits. The projects were given ratings of 0.45 and 0.36, respectively. Given a break-even of 1, these are 55% and 64% below break-even, meaning the cost of the projects are higher than the benefits. Despite Infrastructure Australia's assessment, Rita Saffioti introduced the Railway Metronet Amendment Bill in 2022, Parliament, to enable work on both of these projects. What does this mean to us? We, including the happy employees at Permacast, pay for projects like this with high inflation, higher cost of living, higher interest rates, higher rents. We are paying for these projects now. No pain, no gain is a famous Rita Saffioti quote in relation to the Metronet projects. What she means is all pain to the ordinary West Australian, all gain to the few already wealthy that have access to the government coffers. In conclusion, so how is it that land zone rural managed to get rezoned industrial? How was a huge heavy industry plant being illegally built over several years and operating on land that is inappropriate for this use? How has an illegally operating company been granted government contracts? How is it that a premise that is clearly by all accounts prescribed, suddenly not prescribed? How is it that bush forever land is suddenly absorbed into industrial land? How can stacked steel containers partially painted green be referred to as a noise wall? How is it that complaints from residents about noise, water, dust, traffic, etc. over years be brushed aside? How was the EPA notice rescinded despite no evidence that the noise is within legal limits? Why are the effects of contaminants in cement and concrete on our groundwater not being assessed or considered? I ask myself, what is going on? Is this happening here in Australia? The responsible authority asked you to recommend that MODAP refuse the retrospective approval application in August 2023. One of the reasons being the development is inconsistent with State Planning Policy 4.1, Industrial Interface, as follows. Emissions and impacts from the development extend beyond the boundaries of the site. The impact area of the development is not considered a compatible zone. Development does not properly mitigate or manage impacts on health and amenity of people within the locality, as it exposes them to noise, dust, and vibration emissions. Nothing has changed. This heavy industrial plant is inappropriately situated and cannot control its emissions. It is just ramping up, and the emissions and traffic are only going to increase. MODAP gave them an additional 30 days to rectify their issues. This is an impossible task because of the nature of this huge industry, built illegally too close to residents. Giving them an additional 90 days will not enable to meet legislation unless the legislative bodies lower the bar further. Please vote to recommend MODAP to refuse this application. Thank you for your time.
Thank you, Mrs. McEwen. That brings us to agenda item number 5, which is the Shire President's Report. Good evening, everyone, and welcome to the first Ordinary Council meeting for 2024. As we begin at the business of 2024, let's reflect on the achievements of the first 100 days of this new council. During these 100 days, we enable the community to speak up, engage with us as a council, and we demonstrate our genuine care. We spent more time directly talking to community members, such as hosting highly successful council and community events at the SJ Farmers Markets. These once-a-month events foster collaboration and open dialogue between councillors, residents and ratepayers. I had the great pleasure of meeting members of the Shire community groups in December at the inaugural Community Group Sundowner. This event promises to become a regular occurrence where community groups, which is the backbone of our society and our community, gathered to share ideas and feedback with myself, attending councillors and also the executive. The Sundowner received tremendous positive response, and it was a great way for council to express gratitude for the hard work our community groups do throughout the year. Earlier this month, I had the pleasure of meeting a great bunch of young Serpentine Jarrahdale community members at the first of the Shire's 2024 Skill Up courses, the first one being resume writing, and that was at the Byford Library. The Skill Up program aims at young people in the Shire from 12 to 24. Each individual course equips them with skills to navigate adult life. Upcoming courses will cover topics including first aid, job searching tips, and white card training for the construction industry. If you know a young person who would benefit from training like this, all information is available on the Shire's website. During the first 100 days, we made small but significant changes to the way ordinary council meetings operate. Again, we gave a stronger voice to our residents and ratepayers by offering the option of making statements or asking questions without prior notice. We also streamlined council decisions to be more responsive to community needs by introducing on-block voting. So in summary, the first 100 days of this council were days of significant achievement, with our Shire becoming more transparent and accessible to the people that we serve, and that is our community. Although we're one of the fastest growing local governments in the country, we remain a close-knit and caring community, as demonstrated in our Australia Day Awards. It's a day to celebrate our wonderful people, and I was honoured to meet the award winners and present to them. I'd like to acknowledge Miss Sandra Hawkins, who received the Clement Kentish Community Award for more than 20 years of dedicated service. She's an amazing individual, having assisted with almost every Shire event over 25 years. Lorraine Botel, who was named Community Citizen of the Year for outstanding work assisting people in need wherever she possibly can. And Karen Natello, who is our esteemed Senior Community Citizen of the Year. She works tirelessly to make our community a better place. Her craft shop has enabled countless women to get together, share ideas and provide mutual support. Our Youth Community Citizen of the Year was named Lisa Bailey, and she was actually presented with the award with a councillor, Councillor Reece Jarrett, who was a previous winner of the award. So that was a nice little moment. She's made herself accessible to others at all hours and has assisted with the growth of projects in the Jarrahdale Community Collective. And then the Active Citizen Award went to Munijong Arts and Crafts. They're an outstanding group that started back in 1989, and since then they've become a cornerstone of our community, providing space for people to socialise and connect. I'm sure that you will join me in congratulating all these Australian Day Award winners. As you know, we are fortunate to live among some of the most beautiful scenery in Western Australia. However, this comes with its disadvantages, namely the bushfire. And the southwest bushfire season got off to a busy start at the end of last year. As ever, a local firefighter stood up and challenged the challenge and met it head on. The Shire's dedicated 7 brigades have responded to 231 incidents since the 1st of July 2023, including 14 large bushfires. Their response to the major emergencies in Keysbrook and Jarrahdale was nothing short of exceptional. These are people who work non-stop to protect our communities, homes and livestock, so a sincere thank you from everyone at the Shire to these wonderful volunteers. So I'm proud for what is in store for the rest of 2024 for our wonderful Shire that is Serpentine Jarrahdale. A major events season is continuing, and I encourage as many of you as possible to attend at least one, if you can, event. The Darling Downs Community Barbecue is up this Wednesday, so come along for a snag and a yarn. These barbecues are important to connecting with our community. We also look forward to our community barbecues in Whitby, Jarrahdale and Serpentine in the coming weeks, along with the Harmony Night Festival in March, and of course the most important day of the year, Anzac Day. I'm excited about the major projects we see develop in 2024, and I'll look forward to seeing Kiernan Park Recreation and Sporting Precinct progressing, the delivery of the new Oakford Bushfire Brigade Station and the Byford Skate Park construction, a project which has been shaped by feedback and ideas from our own young people in the Shire. We will continue to advocate for the future projects of the state and federal government to get the best outcomes for all of us in the Shire of Serpentine Jarrahdale. Finally, I'm very much looking forward to the launch of our council plan on Saturday the 23rd of March here in Munijong. This plan truly represents the community's voice, and it's a significant piece of collaborative work involving engagement with hundreds of residents and ratepayers over several weeks. I hope to see as many of you as possible at the launch of this plan, which will help shape the future of our wonderful Shire over the next 10 years. Thank you very much. Item number 6 on the agenda is declaration of elected members and officers' interests. I've just received one, and that is for Mr. Paul Martin, the CEO, who's declared an interest in agenda item 8.1. Being considered by the council this evening on the 19th of February. The type of interest that Mr. Martin would like to declare is impartiality interest as per Regulation 19AA of the Local Government Administration Regulations 1996. The nature of Mr. Martin's interest is that it's the CEO Employment Committee, and that deals with matters affecting Mr. Martin's employment. The extent of his interest is that he is the CEO, and that was signed by Mr. Martin and handed to me this evening. That brings us to agenda item number 7. Agenda item 7.1, ordinary council meeting, the minutes of the 11th of December 2023. Do I have a move for those minutes? Thank you, Councillor Duggan. Do I have a seconder? Thank you, Councillor Jarrett. Is there anyone opposed? Thank you. The motion is carried unanimously. Agenda item 8 is receipt of minutes or reports and considerations of adoption of recommendations from committee meetings held since the previous council meeting. 8.1 is the CEO Employment Committee meeting, 5th of February 2024. The motion is that council receives the unconfirmed minutes of the CEO Employment Committee meeting held on the 5th of February 2024. Is there a mover? Thank you, Councillor Mack. Is there a seconder? Thank you, Councillor Jarrett. Is there anyone opposed to this motion? Thank you. The motion is carried unanimously. That brings us to agenda item 9, which is motions of notice, which has been given. 9.1, motion of notice, review of farmland concessions. I am happy to move this motion. Is there a seconder? Thank you, Councillor Duggan. Is there anyone opposed to this motion?
Not opposed, Shire President, but a question.
Thank you, Councillor Boss.
I know this policy actually came up in the November meeting, and it will have budgetary implications. So I'm curious to understand why it either wasn't amended at that meeting or not considered as part of the budget process. Why right now?
Yeah, thank you for the question, Councillor Bias. Simply because I was spoken to, it's probably not good English, I was contacted by some residents and ratepayers who wanted this matter put forward. So in consultation with staff, I've put the motion forward this evening. I don't know if the Director of Corporate Services would like to add to that, but I'm happy with that response. Would you like to add, Director?
Thanks, Mr. President. I think that sums it up. Thank you.
One further question, if I may, while the Director's got their microphone on. It notes in the report the financial benefits for the ratepayers and obviously the efficiency benefit for the Shire. Do the officers foresee a risk with a longer period of time, being that properties may not be identified and there might be properties that are claiming a concession for a longer period of time when they may not be eligible, if you understand my question, hopefully?
Thank you for the question, Councillor Bias. Director, would you like to answer?
Thank you, Councillor. I don't see a significant risk here. Out of the last assessment that we've done, out of 146 properties, only 8 have changed eligibility. So the change in eligibility is actually quite doesn't happen terribly often. So very low risk.
Thank you, Director. Thank you, Shire President. I don't have any additional questions.
Thank you. I'll call again. Is anyone opposed to this motion? That being the case, the motion is carried unanimously. That brings us to 9.2, notice of motion, Whitby Telecommunications Tower SJ 4373. Do I have a mover? Thank you, Councillor Duggan.
Yes. Mr. President, I'd like to move the motion. However, based on Ms. Brazier's questions this evening, I was just wondering, do the directors consider any additional advocacy that would be beneficial as part of this motion?
Thank you for the question. I'll ask the CEO if he would like to answer that question, or perhaps the Director of Development Services. I'll go to the CEO first.
Thanks, Mr. President. Thanks for the question. I would think that any additional advocacy to Telstra would be a good thing if that was the council's resolution. If the director wants to add anything to that.
Thank you, Mr. CEO, and through you, Mr. President. Yeah, I concur with those comments as well.
Thank you, CEO, and thank you, Director. Councillor Duggan, would you like a moment just to do some wording? Would you like some assistance?
Perhaps if we could, with some assistance, the council requests the President write to the responsible Federal Minister for Communications, Honourable Michelle Rowland MP, and associated telecommunications companies requesting that the federal government urgently assist in completing the new telecommunications infrastructure. How does that sound to the Director? Does that sound appropriate?
Director, Development Services.
Thank you, Mr. President. For communications and maybe the relevant telecommunications provider for this infrastructure. Provider for this infrastructure. Requesting, and then maybe it's just requesting assistance, and then delete the next 5 or 6 words. Yep, yep, and then delete there. That's right. In completing. Yep, that looks fine to me.
Thank you, Director. Are you happy with that, Councillor Duggan?
I'm happy, thank you. That's the motion I'd like to put forward. Thank you.
Is there a seconder for the amended motion? Thank you, Councillor Jarrett. Is there anyone opposed? Councillor Bice, you're opposed? Thank you, Councillor Bice. Councillor Duggan, would you like to open debate?
Thanks, Mr. President. I do feel that this has been a long drawn out affair for the Whitby and Mudgee residents. And I think that this is a good time for us to, as the council and Shire, to stand up to represent those residents. The reasons being are well listed in the recommendation. We have an area where people have to walk out onto their driveway to make a phone call. If we have fires go through, we don't have an easy, accessible way for them to be able to contact people. If they have somebody who is unwell in their house, if the worst thing happens and they are trying to give CPR, they cannot use their phone because they would have to leave their loved one to go out onto the driveway to be able to contact emergency services. I think that's totally inappropriate, and I think that it's a shame that we even need to look at bringing this to the table. But here we are, and I hope that it gets the support from my fellow councillors. Thanks.
Thank you, Councillor Duggan. Councillor Jarrett, would you like to speak or reserve?
I'll reserve, President Coles.
Thank you, Councillor Jarrett. Councillor Bice, would you like to speak against?
Thank you, Shire President, and in the interest of being as truncated as I possibly can, it's no small thing to write to a Commonwealth Minister, so I do think that we need to exhaust all other options before we hit that button. I'm supportive of working with the telecommunications company in question, but I think that avenue needs to be fully exhausted before we go down that path. Thank you.
Thank you, Councillor Bice. Does anyone like to speak for the motion? Thank you, Councillor Duggan. Would you like to close?
Thanks, Mr. President. I appreciate comments, Councillor Bice. Certainly, I feel that we have already taken steps to talk to the telecommunications company involved. Has that been exhausted? No, we have brought forward the motion this evening with that additional information to continue dialogue with that. However, I feel it is well timed. This has been going on not just for the amount of time that it's been in council, but for much, much longer since Whitby was first built. So I think that it is time for us to stand for our residents and to send that letter to the minister. Thanks.
Thank you, councillor Duggan. All those in favour of the motion? All those against? Motion is carried 4-1. Thank you. The next item on the agenda is 9.3, notice of motion, lot 123 and 124 Gordon Road, access Serpentine. I will not be moving this motion, and under our standing orders, that motion will lapse. Next item on the agenda is the en bloc. As part of the Shire's efforts to ensure the efficiency and effectiveness of meetings, tonight's meeting will include the opportunity for matters to be considered by council en bloc. This means that a group of matters dealt with in multiple reports can be grouped together, considered and voted upon in a single motion. Matters that are not to be included in en bloc decisions are those which require absolute majority, matters to be determined behind closed doors, declared interests made in relation to an item, and deputations or statements in which relates to the item. Officers have prepared a list of matters that meet this criteria. I will now read those report numbers and titles and invite any elected member to identify any matters they wish to be removed from the en bloc consideration. Removing a matter from the en bloc consideration does not signify objection to a matter, and it does not require the matter to be debated. Removing a matter from en bloc simply means that the matter is to be considered separately. The matters that have been identified for consideration en bloc at tonight's meeting are as follows. Report item 10.1.3, which is a revised draft planning policy 1.4 advertising development applications. 10.1.4 proposed metropolitan region scheme amendment, Jarrahdale Parks and Recreation Precinct, request for comment. 10.2.1 minutes of the Rivers Regional Council meeting 14th December 2023. 10.2.3 award request for tender RFT 12 of 2023 backhoe loader. 10.3.1 confirmation of payment of creditors December 2023. 10.3.2 confirmation of payment of creditors January 2024. 10.3.3 monthly financial report November 2023. 10.3.4 monthly financial report December 2023. 10.3. I need glasses. 10.3.6 2023-2024 rural valuation review. 10.4.1 Anzac Day consultation outcomes, service location and Dolly Road Cenotaph relocation. 10.4.2 local emergency management committee information report. 10.4.3 bushfire advisory committee BFAC receipt of minutes and considerations of recommendations. They are the items that have been listed to be passed en bloc. Could councillors please indicate if they wish to remove any of the aforementioned reports from the matters to be considered en bloc? Can I then have someone to move that those listed motions all get passed en bloc? Thank you, councillor Duggan. Is there a seconder? Thank you, councillor Mack. Is anyone opposed? Thank you. The motion is carried unanimously. The next item on the agenda is 10.1 Development Services Reports. 10.1.1 Lot 60, 394 Robertson Road, Carter, retrospective and prospective industry, concrete product manufacturing facility. I'm happy to move my alternate motion as has been circulated and should appear on the screen. Would you like me to read that out?
Mr. President, I think for the gallery, it's benefit to read out the alternative motion. Yes.
Okay, so alternate motion 10.1.1 as moved by me is that council resolves the following responsible authority recommendation that the Metro Outer Joint Development Assessment Panel refuse DAP application reference DAP 2302-462 and accompanying plans attachment 12 in accordance with clause 68 of Schedule 2 deemed provisions of the Planning Development Local Planning Schemes Regulations 2015 and the provisions of the Shire of Serpentine Jarrahdale Local Planning Scheme number 3 for the following reasons. 1. Insufficient information has been provided to demonstrate that the development will not result in unacceptable and adverse amenity impacts on residents within the separation distance between industrial and sensitive land uses, specifically in terms of noise. 2, the development is not consistent with the cut-up business plan, local structure plan, which is required to be given due regard under the local planning scheme number 3. Specifically, the structure plan states under Part 1, Table A, Row 2, that any impacts of development with respect to emissions, i.e. dust, gas, odour, light, fumes and noises, shall be managed in accordance with the Environmental Protection Authority guidance for the assessment of environmental factors number 3. Separation distances between industrial and sensitive land uses, EPA 2005. The application does not contain sufficient information to demonstrate that noise emissions are able to be managed. 3, the development is not consistent with State Planning Policy 4.1 Industrial Interface for the following reasons. 1, insufficient information is provided to show the emissions and impacts from the development would not extend beyond the boundaries of the site. 2, in the event the impacts do extend beyond the site, the impact area of the development is not considered as a compatible zone, as it is zoned rural, residential and development. 3, the development does not contain sufficient information to show that it can properly mitigate or manage impacts on health and amenity of people to the locality pertaining to noise. Is there a seconder for the alternate motion? Thank you, Councillor Duggan. Is there anyone opposed?
Not opposed, Shire President, but a question to the Director, if I may.
Yes, you can, Councillor Vice.
This is probably going to be a niche governance question, but I'm curious to understand from the directors dealing with the MODAP. We have a previous RAR from August last year. That is basically the refusal RAR, the refusal recommendation. If council were to endorse the officer's recommendation concerning the deferment and the MODAP, the panel were of a mind not to defer it, would the Shire's recommendation default back to the refusal or would it require a new reconsideration? I hope that makes sense.
Thank you for the question. Please answer. Director, if you can. Thank you.
Thank you, Mr. President. So the recommendation that is passed this evening is the recommendation to the Development Assessment Panel. If the Development Assessment Panel were of a mind to want to issue an approval, the practice is that there's an option 2 in this report, and that option 2 is a option for approval, and that would be the set of proposed conditions if we were requested by the chair person of the panel to submit conditions. So there would be no further report or otherwise coming back to council.
Just want to clarify.
Yes,
Mr.
you
President.
can, Councillor Vice. Yeah.
I'm not trying to predict what council may or may not do, but if it were the officer's recommendation concerning the deferment, so that's what goes to the MODAP. If MODAP weren't of a mind to defer it, then what is the Shire's position? Do they consider that the resolution from August is council's standing position, or do we not have a position because it was deferment without a position, if that makes clearer sense?
Thank you for the question, Councillor Vice. Director, can you please answer?
Yeah, thank you for the question through you, Mr. President. We're being asked to submit a new RAR, Responsible Authority report, based on this updated information. If we resolved a deferral and the Development Assessment Panel were not of our mind to support that, there's no additional resolution or position of council that they would be considering. They'd be considering whatever is resolved this evening.
Thank you, Director. Thank you, Chair President. I don't have an objection to this motion.
Thank you, councillor Bias. Is there anyone? I'll ask again if anyone's opposed to the alternate motion. That being the case, the motion is carried unanimously.
And of course, Mr. President, we'll need a reason for the difference from the officer recommendation. And given it's a matter, it might be worth taking some time to think about that.
I have made some notes, Mr. CEO, but as usual, I'll look at the Director of Development Services to see if this is couched in the right terms. That is to ensure the amenity of local residents and ratepayers, in particular to noise. Local residents and ratepayers, in particular to noise. In particular noise. Or particularly it's fine. Yeah, particularly noise. Yeah, thank you. Thank you, Director. Is that robust enough?
Yeah, thank you. Through you, Mr. President, I think based on the reasons which do focus in on the noise aspect, then that appears appropriate to me.
Thank you, Director. Thank you. That brings us to item 10.1.2, which is proposed road naming application lot 9,550 Warrington Road, Byford. Is there anyone that's happy to move this motion? Thank you, councillor Duggan. Is there anyone happy to second the motion? Thank you, councillor Matt. Anyone opposed? Thank you. The motion is carried unanimously. That brings us to agenda item 10.1.3, which has been moved on block. 10.1.4 has also been moved on block. At 10.1.5, update regarding draft master plan for lot 500 Lampeter Road and request for Western Australian Planning Commission to initiate Metropolitan Region Scheme Amendment, lot 500, number 10, Lampeter Drive, Mardella. Is there a councillor that's happy to move the officer's recommendation?
President Coles, I'm actually respectfully requesting if we can defer this decision under Standing Orders 3.10.6b, so for the council to defer until we have a chance to review this at a PCF, please.
Thank you, councillor Duggan. If I can just ask a question to the Director of Development Services, deferring, will that have any second or third order ramifications or issues?
Thank you for the question. None whatsoever.
Thank you, Director. Is there someone who is happy to second the deferment?
Mr. President, can we just help minute secretaries get the exact wording of councillor Duggan's motion first, so the council defer the matter for discussion at a policy concept forum? Is that what you're suggesting?
Yes,
Councillor Duggan?
please.
Yep. Councillor Duggan, are you happy with that wording?
Thank you.
If I can just ask a question to you, Mr. CEO, is there a requirement to have a date of an OCM, or is that, we can leave it open such as that motion?
Mr. President, I think if we leave it open as that, we can bring it to the next policy concept forum and then consider where it goes to from there.
Thank you, Mr. CEO. Is there a councillor who's happy to second the motion of deferment? Councillor Mack, is there anyone opposed? Thank you. The motion of deferment is carried unanimously. Next item on the agenda. Thank you, Councillor Duggan.
Reason for difference is to allow further consultation with councillors and discussion as to best use of this land. Thanks. Sorry, can someone read it to me? Thanks. I just can't read it from here.
There's the reason the difference is to allow further consultation with elected members.
Yeah, that's sufficient. Thanks.
Thank you. Next item on the agenda is 10.1.6, the Shire Pound and future options. 32 Watkins Road, Mundijong. I believe there is an alternate motion that has been circulated.
Thanks, Mr. President. I'd like to put forward alternate motion. Thank you.
Can you please read that? Thank you.
Certainly. So the alternate motion is that the council requests the Chief Executive Officer to present a business case as part of this year's 2024-25 financial budget for the purpose of engaging a consultant to prepare a feasibility study for the Shire's pound facility. This is to investigate, one, the cost benefit analysis of an interim upgrade of a dog and cat animal management facility at Pound Reserve. Two, options of utilising any locally available private kennels and the cost benefit of this. Three, options of utilising an adjoining local government's animal management facility and the cost benefit of this. Thanks.
Thank you. Is there a councillor that's happy to second the alternate motion? Thank you, Councillor Jarrett. Is anyone opposed to this motion? Motion is passed unanimously or carried unanimously. Anyone need difference? Thank you.
Thanks, Mr. President. Reason for difference is to allow immediate improvement in pound conditions until a more permanent solution can be in place. Sorry, to allow immediate improvement in pound conditions until a more permanent solution can be put in place. Thank you.
The next item on the agenda is 10.2, Infrastructure Services Reports. 10.2.1 is minutes of the Rivers Regional Council meeting 14th of December. That has been moved on block. The next item on the agenda is 10.2.2, award request for tender RFT 14 of 2023 patch truck. Is there a mover for the officer's recommendation? Thank you, Councillor Duggan. Is there a seconder? Thank you, Councillor Mack. Anyone opposed to this motion? Motion is carried unanimously. 10.2.3 was moved on block. At 10.2.4 is Soldiers Road Principal Shared Path PSP project update. Can I please have a mover for the officer's recommendation? Thank you, Councillor Jarrett. Councillor Duggan, you happy to second?
Happy to second.
Thank you. Anyone opposed to this motion? Motion is carried unanimously. Next item on the agenda is 10.3, which is corporate services reports. 10.3.1 has been moved en bloc. 10.3.2, I'll just read that out, is confirmation of payment of creditors for January 2024. That has been moved en bloc. 10.3.3 is monthly financial report November 2023. That has been moved en bloc. 10.3.4 is monthly financial report December 2023. That has been moved en bloc. 10.3.5 budget adjustment for unallocated surplus. Do I have a councillor who's happy to move the officer's recommendation?
I would like to make an alternate recommendation to defer this item, if I may.
Certainly. Again, I'll ask the manager of corporate services, will that have any real implications or effect?
Thanks, Mr. President. No, that should have no flow-on effects.
Can I just ask, Mr. President, are we deferring it to a policy concept forum?
Sorry, yes, I should clarify to defer this to a policy concept forum to bring forward the discussion about the overspend from the Kiernan Park project.
Councillor Mack, could you please just repeat that?
Defer the matter to the next PCF to discuss the Kiernan Park BMX relocation detailed designed overspend, which has come from our municipal funds budget, to get a better understanding of the overspend.
We're a little bit slow, Councillor Mack, because the minute secretary is typing.
Thank you.
Thank you, Councillor Mack. Is there a seconder for the alternate motion? Thank you, Councillor Duggan. Is there anyone opposed to the alternate motion? Motion is carried unanimously. We need a difference, Councillor Mack, please.
For officers to provide further details to councillors regarding the overspend on the capital works projects. Yeah, that's great. Thank you.
The next item on the agenda is 10.3.6, which is the 2023-2024 Rural Valuation Review that has been passed en bloc. The next item on the agenda is 10.3.7, Shire of Serpentine Jarrahdale Integrated Planning, Reporting and Budget Timetable 2024-2025, and there is an alternate motion that has been circulated. Are you happy to move that, Councillor Vice?
I am, yes. Would you like me to read it out?
Yes, please. Thank you.
Point 1 is the officer's recommendation. It adds a point 2, which is requests the Chief Executive Officer prepare and report to Council in March 2024 on options for community participation in the annual budget process that can be undertaken with existing resources, supported by a proposed framework that outlines the .1 eligibility criteria and types of submissions permitted. .2 minimum timeframe for public advertising. .3 format of submissions. .4 criteria and process for assessing and prioritising submissions. The reason for the difference, one I prepared earlier, is to provide our community with a structured and transparent process for putting forward requests for consideration during the budget process. Thank you.
Thank you, Councillor Bias. Is there a seconder for the alternate motion? Thank you, Councillor Duggan. Is there anyone opposed? Thank you, councillors. The motion is carried unanimously. That brings us to agenda item 10.3.8, which is review of delegations and authorisations 2023-2024. Do I have a councillor to move the officer's recommendation? Thank you, Councillor Bias. Is there a seconder? Thank you, Councillor Duggan. Is there anyone opposed? Motion is carried unanimously. That brings to agenda item 10.3.9, which is the appointment of a member to the Carnet Prison Farm Community Liaison Group. And I believe, Mr. CEO, there was a email received.
Thank you. Yes, there was. Councillor Duggan is nominated for this.
So then that would be, and there's only the one is my understanding, so the council adopts the following elected member to the Carnet Prison Farms Community Liaison Group, which would be Councillor Duggan.
You might ask if there are any more.
Are there any other people that are interested in being on this very important committee, which is the Carnet Prison Farm Community Liaison Group? Councillor Duggan, are you happy to move a motion that, actually, what I'll do is I'll move the motion that council appoints Councillor Duggan to the Carnet Prison Farm Community Liaison Group? Is there you have your second, Councillor Bias? Thank you. Is anyone opposed? Thank you. The motion is carried.
Councillor Bias, second.
Yes, sorry. And so I'll just make sure no one was opposed. Motion is carried unanimously. 10.4 is community engagement reports. Sorry, I'll just put 10.4 is community engagement reports. 10.4.1 was moved on block. 10.4.2 is local emergency management committee information report. That too was moved on block. 10.4.3 is the Bushfire Advisory Committee BFAC receipt of minutes and consideration of recommendations. That too was moved on block. That then brings us to agenda item 10.4.4, a Byford Rail Extension Public Art Selection Panel. And I thought I did email, I might not have, but I'm happy to nominate unless there's anyone else who'd like to be involved in the public art, on the Byford Rail Extension Public Art Selection Panel. Councillor Duggan, did you want to speak?
I guess my only question is we do have an election in the North Ward coming up, with it being an area that's covered so closely with that Byford train station. I just wonder if this is one that we could look at deferring until the next meeting when this other person may be interested. It's more a thought bubble that just came to my head than anything else.
The comment I would make, there already has been 2 meetings and I was involved in one on last Friday. I don't know whether the Director of Community Engagement would know whether if we wanted to post 23 March, whether that would have any effect on MetConnex or Metronet.
In the absence of council appointing its delegate, we obviously have yourself attending. Mr. President, I would just flag that the election isn't occurring until the 23rd of March, so the next scheduled ordinary council meeting wouldn't occur until April, and I'd just be concerned that the art selection process would be nearing the end and that could limit the opportunity that the Shire would have to influence the selection of artworks for its projects in the Shire.
Councillor Duggan.
Thank you for the response, Director.
I'm happy to nominate myself, unless there's another councillor that would like to be involved. That's said, I did attend last Friday.
I'm happy to move the motion that we nominate President Coles for the position.
And then would you like to nominate a deputy, or is there someone that would like to be a deputy? And I don't know whether we can leave it blank for the TBA councillor of the North Ward election. I think that would probably be bad governance, would it?
I think that would be fine. If we can get a member endorsed, that would be a good outcome tonight. And we could represent the report for council to consider a deputy in April.
Thank you, Director of Community Engagement. Are you happy to move that, Councillor Duggan?
I'm happy to move.
Is there a councillor happy to second that motion, which only has one member, no deputy? Thank you, Councillor Jarrett. Anyone opposed? Motion is carried unanimously. Oh, sorry.
Might be just to allow consideration of the deputy post the election.
You must have read what I had written down, Mr. CEO.
Motion.
Thank you. I'm happy with that wording. Thank you.
Just carried
Carry
unanimously.
it, yeah. Thank you. That brings us to agenda item 10.5, which is Executive Services Reports. 10.5.1, nominations for position on Peel Development Commission Board. I believe you have received nominations for this one, Mr.
I have,
CEO.
Mr. President. I've also received an indication from the Peel Development Commission since publishing the report that in fact there are now 2 local government vacancies on the Peel Development Commission. So in fact, council could nominate 2 people to be considered. They can actually nominate 2 people plus 2 deputies as well. So up to 4 councillors can be nominated if they wish, or you could just council could just nominate 2 people to be considered for the 2 vacancies that are available.
So you have received, I think I've nominated. Is there any other councillors that have nominated?
Councillor Duggan's also nominated in writing as well.
Are there any other councillors who'd like to be involved in the Peel Development Commission? I thought the Director of Infrastructure put his hand up there, but is there someone happy to move that the President Coles and Councillor Duggan are the 2 nominees? Thanks, Councillor Jarrett. I'm happy to second it. Is anyone opposed to the 2 nominees? That motion, I should say. Motion is carried unanimously. That brings us to agenda item 10.5.2, which is Infrastructure Directorate Review, which was circulated last week. Is there a councillor who's happy to move the officer's recommendation? Thank you, Councillor Duggan. Is there a seconder? Thank you, Councillor Jarrett. Is there anyone opposed to this motion? Motion is carried unanimously. That brings us to 10.6, confidential reports is being nil received. Agenda item number 11 is urgent business, which there is nil. Agenda item 12, elected member questions, which notice has been given. There are 2 that we have received. The first one is 12.1, elected member questions, which notice has been given roads that traverse private land. I'm not going to read out the question. The answer has been provided. And that'll be put into the minutes. (12.2) elected member questions, which notice has been given. Shire expenditure, catering, photography, videography, corporate communications. Again, the question has been received and the answer has been provided. I would actually add to the response, and I have a list of other items and I'll ensure that these are reflected in the answer to question 2. And what I would say is that since October 2023, or since December 2023, I should say, is that there has been other videos done, such as the Seniors Week launch, Christmas Lights competition launch, Christmas Lights winners, SMS alert video, and 2 Ordinary Council meeting video wrap-ups. Those videos have all been completed in-house using the existing resources within the Shire, where previously they would have been produced by a professional outsourced company. Thereby, we have saved residents and ratepayers money, and I'll ensure that they are answered in or added to the officer's response to that question. That brings us to agenda item 13, which is the closure of the meeting. I declare the OCM closed at 8:56 p.m. and I'd just like to make a special thank you to the Minutes Secretary for doing an outstanding job tonight. So thank you for your excellent work. Meeting's now closed at 8:56 p.m.